Yes, people. We had started with chapter 10. Yes. So let us complete chapter 10. Okay. So we had seen in compromise and arrangements which are all are the, what is that, laws applicable, correct? And that is where we had stopped. What are the laws applicable? The first one is Income Tax Act. Why Income Tax Act is coming? Because of capital gains, carry forward losses, tax reliefs, and all that reason. SEBI LODR. Why is SEBI LODR coming? Before you go and apply to any tribunal for any mergers, amalgamation, anything, you have to first file it with the stock exchanges. The stock exchange will give you something called as no objection letter or observation letter. So this you need to take it to the court. Before you go to the court, you have to first go to the stock exchange. That's the procedure. And if at all the merger is between a company, holding company and its wholly owned subsidiary, this observation letter and no objection letter is not required. Correct? And next one was Indian Stamp Act. What is Indian Stamp Act? What does it say? Whenever there is a transfer of property, that is conveyance deed, it is for sure we know that it is subject to stamp duty. You need to pay. But the question was whether the court's order, that instrument of the court, is that considered as a conveyance deed? If yes, you need to pay stamp duty. If no, there is no need of paying stamp duty. Now the question was, is it considered as stamp duty or not? Was the whole question. Now in this people, it was decided that we have some cases in the favor of it is not considered as instrument and hence there is no stamp duty. We have some cases saying that it is considered as stamp duty and you need to pay stamp duty on it. So both we have. Of course, whenever there is a conflict, it is always the Supreme Court's order that we prevail. But remember, Indian Stamp Act is always a center act. So the center level, Indian Stamp Act has been passed in the center. However, if you look at our union list, state list, concurrent list is there, right? Now, this particular stamp duty, we also come under, it comes under state list. Meaning every state can have their own law. So now what did some states do? Whatever was the law that was there, that was passed by the center, they copy pasted same thing in their states as it is. So in that, there will be no court's instrument added in the definition of conveyance deed. It will not be there because they have copy pasted what was passed in the center. That is one type of states that have taken the Indian Stamp Act and that has been implemented in their particular states. That is one where they have not made any changes. The second type of states, they have copy pasted the same central act into their state acts with a small amendment that the word conveyance deed will also include court's order has been added. That is the second way of adoption that few states have made. The third way, people, they have come up with their own state specific acts. Nothing to do with what center has said. So these three ways the states have adopted the stamp duty in various places. One, as it is whatever is given in center. In such cases, we will not have court's order in the definition. We will follow Supreme Court's order because that is decided. Article 141 will come there. In the second stage, where they have taken the same central act, they have copy pasted in the state act with a small amendment that the conveyance deed will include the court's order. That's the second way. The third way, they have made their own acts. That's the third way. Is this clear now? Pakka na? That is one thing which we had to know here.
Few definitions, they give relatives, related to. What's the difference between relative and related person?
Relative and?
Related person.
Relative, we generally take it from the human's point of view. A related person can be the body corporate's point of view also. But a company cannot have a relative, no?
In deposit trustee, you have given any other related person. Any other person.
So if it is considered from a person's point of view, correct. So now that related person will be from the company's point of view, body corporate's point of view. And now we will refer to KMP, this person, private company.
Which company is being appointed as deposit trustee from that company's point of view?
Correct, yes. Now imagine if it's a bank. Now generally I told you debenture trustees are always banks only. Now if you're appointing that, then the relative definition will not come into picture. So one company is being appointed in another company. So that time related person will come into picture. Then my director, your director might be common. It is considered as related party. Related party.
Okay, yeah.
Correct? Huh? Okay, next. SEBI SAST. I told you we'll be seeing this more in detail in. ಯಾರೋ ನೆಕ್ಸ್ಟ್ ಟೀಚರ್ ಬರ್ತಾರೆ ಅನ್ಕೊಂಡ್ ಬಂದೇನೋ. Janasagar. How come today more people? Nikita is here today. Where were you today? Saket is there today. ಅಣ್ಣ ಅವಾಗ ಅವಾಗ ಬಂದು ಒಂದು ವಿಸಿಟ್ ಕೊಟ್ಬಿಟ್ಟು ಹೋಗ್ತಾನೆ. ಯಾಕೋ ಮಧ್ಯದಲ್ಲಿ ಬರಲ್ಲ? ನಿಮ್ಮ ಆನ್ಲೈನ್ ಸಿಂಚನ. Where were you today? Oh, see, you were there. You told her, okay. Where were you, da? Me. Hey, all of you told me, da. Oh, is it? Okay. Which program? Okay, correct. Matthews, come on. Chappale. Matthew, people are missing you, da. How are your cats? They are good. Did you get anything here? No, only you came. They are all good in home. Why did you not come so many days?
My parents are on vacation.
But why can't you come? They 4 hours they can't be alone, Ada.
Anything can happen in those 4 hours, no? So I can't give them.
Hey, Macha, if you get married, you'll go with her to office or what? I know that animals and all you have to love, but this much, 4 hours it can't stay, Ada. What will happen? Something means what will happen? You lock the door and come. Okay, pa. Okay, competition actor. What is competition actor? Monopoly, CCI and all. FEMA? RBI when foreign companies involved. Provision of companies actor. Provision of compromise element. We'll see. We need to see. Okay, power to compromise or make arrangement. Section 230. Okay, start with section 230. Okay. Now people see here. What is section 230? Whenever a company wants to make any compromise, arrangements, amalgamations, or whatever is a request. Sir, when will we complete the rest? We will complete it. So, because yesterday the class was cancelled. Anyways, you enjoyed. Why you, sir? I missed and all. Sir, venda. Tomorrow I'll come. We'll be finishing the syllabus also. Illada. I said that the maximum is today is what, Tuesday. So Thursday will be the last day. So we'll be done with company law. Then the next subject will start. Probably it will be JIGL. Ayo sir, I thought I bought a new book also. I wrote accounts also on the first page. Hey, read that. Now my subject has to get completed by Thursday. Simply I said that. I'm sorry, my mistake. I don't know. You wait for an official confirmation because of course lot of things will change. Okay, now see that. So people, powers to compromise or make arrangements with members and creditors. Powers to compromise and make arrangements. People now see here. I told you one section also, section 230, where this particular section was recently looked at. Which section? I mean, in one topic we saw section 230. Wrong.
Operation and mismanagement.
Wrong.
Around the 96 or
Wrong. Operation and mismanagement 241, 242, 244 now will come. Where 230 came the?
reduction of salary.
Wrong.
Distribution of profits.
Wrong. Yes, people, when we. Wrong. Now, people, when we saw DVR, I told you, generally, a DVR share cannot be converted to a normal share. A normal share cannot be converted to DVR share. But I told you, Tata DVR, it happened. For 10 shares, you got 7. How? I told you, they went to tribunal approval. Where? They went to where? Tribunal approval. You remember? So people remember, whenever there is a compromise, BD, this is not compromise. Whenever there is an arrangement, it's an arrangement. Sir, we have a DVR share. We will give you normal share. Is it okay? It's an arrangement. Now, if at all tribunal is accepted, if people are accepting it, in such cases, people, what we are going to do is this particular chapter. I mean, this particular section. That is one way. Next one, sir, compromise. What do you mean by compromise? Now, whenever, let us imagine, debtors, Vijay Mallya, that the company owes some money to the bank. We are not able to pay the complete amount. Now, what will Vijay Mallya do? Vijay Mallya will go and do a compromise. He will say, I will go, I have to pay 9,000 crore. I will not be able to pay. I will give you 4,000 crore. Are you guys okay with it? Now, that settlement order that you guys are going and trying, that will also come in this particular section. And that is what is called as people compromise, arrangements, amalgamation. Mergers will come 232. That time I will tell you what it is. Clear? So today, if any company wants to take over another company, if Vodafone Idea wants to come and merge with each other, in all the places, 230 to 232, 230, 231, 232, all three will apply. It's clear? Sir, for example, some company wants to take over another company. What is take over? Acquire. So, whenever an acquisition is happening, ownership is getting transferred. Again, people, this chapter will apply. This particular section will apply. And I told you this one, arrangements. What is arrangements? Like simple, 10 share, 7 share. This particular section will apply. That is what is this applicability. Understood? Hello? What and all does arrangement include? Okay. This is what they define it. The word arrangements and compromise is not defined. But what does it mean? This is what they are telling you. Let us see if it helps us. Compromise means a peaceful peace or willing settlement Vijay Mallya Anna of a dispute by mutual adjustment and concession. Concession, Anna, I have to give 9,000 crore. I'll give you 5,000 crore. Okay, va. I'll tell you. And the arrangement, there is no dispute, but it modifies the rights. There is no dispute, but it modifies the rights. Correct? DVR. You were getting some share, now you are getting some other share. The rights are also changed. It modifies the rights. Yes or no? Such readjustment of rights may be with members or class of them or creditors or class of them. The term arrangement is very wide and can include a reorganization of capital also. Capitalizing DVR into normal share is considered as arrangement. But what is the basic difference between the word compromise and arrangement? In a compromise, there is always a dispute. Meaning a little heated argument is there. It can be even a case, it can be even you filing it some authority officially. In the case of arrangement, people, it is always, we assume that there is no dispute as such, but the rights will always be modified. Yes, sir. Hello? Pakana? Clear? Okay. Now people see here what will happen in this section. Powers to compromise or make arrangement with member and creditor. Section 230. An application filed by the applicant. Applicant means what? There is an application being filed. With who? With the tribunal. We are filing an application. Who is filing? Applicant here can be company, Kingfisher, creditor, ICICI Bank, member, Vijay Mallya, or liquidator if the company is in the process of winding up. So who and all can file? Applicant can be company, creditor, member, or liquidator in the case of company being wound up. Why winding up? Why liquidator is coming? Even when liquidator is coming, your compromises will happen. Now imagine I have 10 lakh rupees debt. I have 2 lakh worth assets. Whom should I pay? Whom should I not pay? There will be some compromises. That's why liquidator is coming. Okay, wow. Next one, sir. Now we are filing an application. Applicant, we got to know. For what are we filing an application? We are filing an application for compromise, arrangement, or even a takeover. This will even add a merger also here. Why right now don't write? I'll tell you when it comes. 232 is merger. When it comes, I'll tell you why I wrote merger here. You don't write now. You wrote a it's okay. Now people, so I'm filing an application for compromise, arrangement to takeover. Hello? We are filing noda. Okay. Now sir, this is between who? Between the company and the creditors, or between the company and its members, between the company and class of creditors or class of members. What is the difference? Creditor means one person, class means everyone. Meaning we have 100 debenture holders. We are entering into a compromise with one person, or we are entering into a compromise with all the 100 debenture holders. It's called as class of creditors. Say member one person, class of members the entire group. Hello? Okay. So we are filing an application for compromise, arrangements, or takeover with our creditor, class of creditor, or member, or class of member with the company. Agreed? Hello? Okay. Now whom are we filing all these applications to? We are filing this application to NCLT, that is our tribunal. Till now any doubt? No. Sir, along with this particular application, we need to give certain disclosures, statements, and all that it seems. What is this disclosures and all? I have to give all the material facts about the company, like financial statements, P&L accounts, your cash flow statements. If any other documents are required, all those things I need to give it to NCLT. Okay. Audit reports, board reports, I need to give all these details. Okay. Scheme of, what is CDR? Corporate debt restructuring. Corporate debt restructuring. So a scheme of CDR consented by 75% of secured creditors in value, including creditors responsibility statement, valuation report. What is CDR, people? Now Kingfisher is filing. We have an overall debt of 9,000 crore. Now we want to restructure this debt. Of course, I cannot pay 9,000 crore. Then how much you can pay? 5,000 crore. But are the creditors okay with it? Sir, creditors include both, sir. Secured as well as unsecured. Should I take everyone's approval? For now, before you give me a scheme, that what is the scheme? 9,000 getting converted to 4,000 or 5,000. You want to settle it. That is called scheme. What do you mean corporate debt restructuring scheme? Scheme is nothing but what is that you are going for a proposal. Meaning what is the compromise you are offering. The total you need to pay is 9,000. You guys are telling I pay 4,000. That 4,000 also will you pay upfront? Or you will take time? What is that? Express that. Okay, where should I express? You express on a paper. That is only called a CDR scheme. Corporate debt restructuring. You're restructuring, no? Yes or no? Yes or no? That scheme you give it, which is agreed by 75% of the secured creditors. Unsecured, unsecured, I'll tell you when they will come. Currently, 75% of the secured creditors, if they have approved, then you give me that particular scheme. If they are not approving, then you cannot propose that at all. So you give such scheme which is approved by 75% of the secured creditors. Along with that, now imagine, sir, we have seen in one chapter share capital and debentures. In that, when we saw, can a share be issued at a discounted price? Can we issue? We saw two exceptions. What is the exception? One, sweat equity. Second one,
Debt to government.
tell that word only, da. Debt restructuring, da. That is only this, da. Oh, correct. Now, people, debt restructuring. There is a debt in the company. I am allotting some shares in the place of debt. Can I do it? It is accepted there. Now I want to do it. How many? What? What is the proportion? For how much of debt? How many equity shares you will get? Now all that will be decided in a valuation report. So you need to attach all of this in the application. You are filing it with the register. To the tribunal. It's clear? Hello. Okay. Next one, protection for other secured and unsecured creditors. What is that protection? I'll tell you. Now we have filed all this application to the tribunal. Any doubt till now? Okay. Now what will the tribunal do?
What's the difference between CAA and IBC? Both involves debt, no?
IBC will come when there is a minimum amount involved. 1 crore should be minimum there. Less than that, IBC does not address it at all. So this is internally you manage. IBC is external management. Fail also I will not say when the number is less or when you want to continue the business. There it will happen in a more stringent way, expensive. Yes, and this is when you guys only can agree. When you are not able to agree, you will go to IBC. People. Okay, now see here. We have filed an application. What will NCLT do? See here. The tribunal. What happened? Yeah. The tribunal will order to conduct a meeting for which hey, what is this? Paranormal. Oh, tab. Okay. Now we will see here. We have filed an application to the tribunal. The tribunal will order to the tribunal will order to conduct a meeting for which a notice of a meeting shall be sent to. Now what is it, people? The tribunal has received the application. Now the tribunal cannot decide everything on its own. End of the day, the compromise or arrangement has to be made between the company and its members, company and its creditors. So what will tribunal tell? Hey, you do one thing, the company, you directly meet your creditors and you directly meet your members. If they don't have a problem, I don't have a problem. So what will the tribunal tell? Tribunal will tell the company to conduct a meeting. Now my question to you, what is this meeting called? Where did you see this reference? Tribunal is telling that company to conduct a meeting. Understood? Tribunal conducted EGM da. Hello, in our childhood, when we were still discussing about ultra buyers transaction. You remember da? So people, when we were seeing about the tribunal conducted EGM section 98 will come here. The tribunal is telling you to conduct a general meeting, no da? Yes or no? Nitin, no? What will be there in that content? The tribunal tells you to conduct a general meeting. What and all the tribunal will tell in that particular notice? It can specify some conditions, no? What will it specify? Very good, Nitin. I appreciate you, Nitin. Nitin. Hey, Nitin. Second bench, Nitin. Tell da. Even one person being present can be considered as quorum. Proxy can be considered as quorum. So that can be specified. That is where we wrote in section 98. Okay, anyways. Now people, I will be telling a tribunal is sending a cold. Okay. You are not feeling cold. Okay, now people, the tribunal is telling to send a notice to all these people who, of course, we want our creditors to attend the meeting. Of course, we want members to attend the meeting. Class here means what? Group. Debenture holders. So wherever it is required, with whomsoever you are entering into a compromise or arrangement, you are conducting a meeting with such particular category. Hello? Okay. Sir, we will also send a notice to people our central government, RBI, IT, SEBI, ROC, Stock Exchange, Competition Commission of India, liquidator, any other sectoral regulator as per the industry that company is working. If it is an insurance company, IRDA. Meaning if you as a regulator, do you have any problem? AU, SEBI, do you have any problem? RBI, do you have any problem? The company is coming for a compromise or an arrangement. Do you have any problem? A meeting notice will be sent to all these people. Now, what is the next thing? Now, sir, if at all they have any no objections, who? These people, authorities. If they have any objections, they have to file their objections, people, within 30 days. Representation, if any, is to be made within 30 days. If not, a no objection will be presumed. This is for whom? The authorities. Who are the authorities? Registrar, SEBI, it can be liquidator, it can be IRDA, it can be PFRDA, CCI, IT authority, central government. If they do not reply within 30 days, it is presumed that they don't have any objection. Hello? Understanding? Okay, sir. Sir, what about members and creators? What if they have an objection? They, for them only, we are calling a meeting. The meeting will be conducted. Now, in the meeting, people, remember, for us to carry on this compromise or arrangement, we need certain minimum votes. If we do not get the minimum votes, people, then we cannot carry on this compromise or arrangement. Now, what is that minimum votes, sir? They say, for a scheme to be approved, majority of person representing 3/4 in value of creditors, or if it is members, approval is required for a scheme to be approved. Now, what are we saying, people? You need a majority of person representing 3/4 in value. Macha, pay attention here. This is important. What is it, sir? There's a dual condition involved. What do you mean by dual condition? Yeah, macha, we are converting the Tata Motors DVR share into normal share. We will call all the DVR shareholders to a meeting. We will say, for whatever 10 shares you guys are holding, I will give you 7 normal shares. Is it okay for you? I need to get an approval. How many people have to agree? They're telling I need to get a majority of number of people approval. Meaning there are 100 people in the meeting. 51 people have to agree this particular compromise. Provided this 51 people should be holding 3/4 in value. Special resolution also is required, but number of people agreeing it should not be 1 or 2. The people should also be majority. Rarely you will see this. Where else you saw this?
EGM, shorter notice.
Very, very good. You saw it in shorter notice. Understood? Love you. Very, very nice. Touched. Okay. Now understood. Majority of person and 3/4 in value. Very, very important. That is the condition. Because in exam they will specifically pick that. They will give you the numbers. They will pick this particular scenario. Are you getting it, all of you? I hope you understood this. If 100 people are there, majority number means what? 51 people. This is number of people. Shareholding. What if this 51 people are holding some 10% of shares? Then you cannot do anything. We need majority number. This number should also hold at least 3/4 in value of the shares. Then you can do something. Getting it? Hello? Pakkana? Okay. Sir, this is for approval. Meaning for the scheme to go through. What if we do not want the scheme? Then object it. So how many people should object? People, 234 says by members holding minimum 10% of shareholding. Creditors having minimum 5% of total outstanding debt. Now people see here, this is voting, this is objection. Split it there clearly. The left one is voting, the right one is objection. Clear? So that they're telling you, if at all someone has to object the scheme, it should be people, members holding minimum 10% of shareholding. If it is creditors, people, the creditors holding 5% of the total outstanding debt. Outstanding means what? Whatever is not yet repaid. On that, whoever is holding 5%, now they can go and object the scheme. Hello? Pakana. Remember these sections, which section 233. What is 233? To whom and all we are sending the notice of a meeting to personally attend. Creditors, members, or debenture holders. 235. We will also give our notice to certain authorities. That is all CGIT and all those people. 234 speaks about objection. That is, if members are 10%, if creditors are 5%. 236 says approval. Approval, John, how many? Majority in number, 3/4 in value. Whether it is members, then members. If it is creditors, creditors. Remember this, very important. In 232, the reference will come to these 4 subsections. When we are doing section 232, they will give a reference to these 4 subsections. So remember this. Hello? Pakana? Okay. Or liquidation by company being voted. Voting can be done by person or by proxy or postal ballot, as the case may be. Section 234. That is voting thing only. It will come. Is clear? Hello?
Voting. What the condition?
See, 100. You got 49 people approved. That's all scheme comes to an end. Sir, we got 51 people approval. Sir, value is people. The 51 is holding 60%. People, that's all the approval comes to an end. The compromise, that is the scheme will come to an end. That's why we say it is a twin condition. A majority of person representing 3/4 in value. Both are to be met.
Person who are holding a majority actually, but
Not happening, scheme doesn't go through. That's all.
company should not.
74% you get also, you will not be able to do this. The scheme will come to an end. You should get 3/4. That's the condition, right?
Company still like that. Persons are not holding three. Like most of the people are not holding three. They are holding minimum.
How can that happen? 100 people put together should be 100%, right? In your company, how can you have shareholding less than 100%?
Like 1% is holding like less than. Most of the people are holding less percentage.
So you take public only, you have to come together. You need to get 75%. That's all. As simple as that. Everyone have to act together. So if you are holding, I am holding only 0.5%, sir. That is okay, because you have to act together. These are all collective decisions. That's why we are saying majority. 75% is required.
It's dumbed out. It says the 3/4 in value is 75%. But still the members holding up to 10% can reject.
Correct.
What if okay, sir?
Very good. Now, whenever such thing happen, have we seen such scenario? Mithun will say one such scenario. What will happen? Somewhere we have seen a similar scenario where 3/4 will apply, but 10% will reject. Where did you see?
Variation.
Variation. Oh, hey. I just tried. It worked. Variation of shareholder rights. We said if at all 10% of the people have any objection, they will go to the tribunal. Now, whatever tribunal's order, that will be final. Same thing will happen. They will object. Whatever tribunal's order, the tribunal's order will be final. Clear? Okay, now understood. The people, after all of these people, you get an application. Okay, see, okay, oh, you done that today. You will never concentrate today. Done. He's already saying, hey, eppadi paatya, hey. Yes, sir. Now see here. I'll tell that. Now people, Mithun says, sir, all this meeting and all mandatory, sir. Can we skip it? Why all this meeting and all? Because Mithun asked the people, they said, only for Mithun. Tribunal may, meaning what people? At the discretion of the tribunal, it may dispense. Dispense means what? It can ignore, it can waive off the condition. Which condition? Condition of holding a meeting. When? With the calling of a meeting of creditors, if minimum 90% of creditors in value agree and confirm by an affidavit to compromise arrangements and amalgamation. What do you mean by that, sir? Sir, when we give a request only, in the written request only we said 90% of us are okay with this. Meaning what is happening, people? Vijay Mallya and ICICI Bank, before going to tribunal only, they already entered into an arrangement. He went and convinced them, for 9,000 crore I will be paying 4,000. Are you guys okay with it? If they are saying okay here, Then why again go to tribunal? Tribunal will give build up, they will conduct a meeting, they're 3/4 in value. I'm getting already approval here. ICICI is the one who needs to say yes. Now they're telling you, if you're able to get a consent of 90%, then people, we can dispose of the conducting of a meeting. Yogita will say, sir, for the 10% no value? Are you not valuing the 10% of the people? You're saying only 90% required. What about 10%? No respect? Remember, that's why I said it is tribunal may. Tribunal, if it feels that no meeting is required, tribunal may still conduct a meeting. It may still call for a meeting. It is absolute discretion of the tribunal. Is this clear?
That below point, so if there are two creditors and the compromise is between, so even if one rejects, they have to conduct.
Correct. Because only 50% you would have got that time. Hello? Now people, now the scheme is approved, people. Let us imagine meeting was conducted. The scheme is approved. Such approved scheme shall be forwarded to NCLT. Hello? Such approved scheme shall be forwarded to NCLT. Now NCLT may pass the following orders. What will NCLT pass, people? First one, if scheme is for converting preference to equity, that is the arrangement they are doing. If the scheme is for converting preference to equity, an option will be given to the preference shareholders to collect the arrears of dividend by cash or equity. What do you mean by that, sir? We are converting almost, say for example, 20,000 preference shares. We are converting it to, say for example, some 5,000 shares. That is, for every 4 shares, you will get a 1 share. That's the proportion. Sir, on this 20,000 preference shares, there is an accumulated dividend of, sir, around 2, say for example, 20 lakh rupees. There is an accumulated dividend. This is clear, huh? Now, sir, when you are converting, when the complete scheme is for converting preference into equity, that's what the scheme compromise is going on. They're telling you, the scheme, you can go with it. That is approvals and all, 3/4 majority and all, that you go as it is. But whatever is a conversion, this dividend part is there, no. This should be given an option to the preference shareholders, whether they would like to receive this in cash or they want this also in equity. It's absolutely their discretion. If they say we want cash, you need to pay cash. If they say we want, it's okay to convert that into equity, you can convert that into equity. Clear? Hello? Amma, tell da. Good, okay. Protection of any class of creditors. Tribunal can clearly say, hey, that class of creditors, hey, unsecured creditors, what about them? You give protection for them. Only then I will approve the scheme. Tribunal can pass an order. Third one, if scheme results in variation of shareholder rights, Mithun says, sir, that comes under section 48. That is what tribunal is also telling. If at all, whatever your scheme or arrangement, if it is involving variation of shareholder rights, you should also comply with section 48. Not only this section is what they are telling you. Next one, sir, scheme is approved by creditors, then proceedings before BIFR shall stop. What is this, people? What is BIFR? We saw this somewhere. Where? KMP, Managing Director's chapter. If you remember, people, in certain places you can pay excess remuneration. Where did it come down? Section? Only Yogita got it till section? Schedule 5. Very, very good. Hey, today Srishant give him of the man of the match. Section 3, people, if you remember, scenarios where you guys can pay excess remuneration than given in section 2 was given in section 3. What are the scenarios where you can pay? Sick company, one, then Anaga said one. Now, Abhiram will say one more. Matthew will say online. Matthew will say, now see his concentration power. Now you will know. Tell Matthew. Don't give build up, you don't know. Stop doing this Shudra Puja. Nanda will tell Nanda. What are scenarios where I can pay excess remuneration than given in section 2, but without having to pass special resolution? Keithan is like, sir, don't ask me, I don't know. Now only he's silly. Co-villain will tell now, see da. Co-villain tell da. You know, tell da. Think you will know. Kanishkar will tell. I can only rely on him. Yes, Kanishkar, tell da. Okay, build up da. One try da. Correct. And your own da. Your own. Something related to startup. Newly incorporated company for a period of 7 years. Abhijit, sir, 7 years. What else? Professional capacity.
And they have corporate research.
Professional capacity.
They can pay excess apartment.
That is corporate.
That comes under section 2 limit B noda.
But like where they can pay excess revenue apart from the guarantee.
Okay, leave. Okay, understood. I understood. You all understood. Okay. People, next one, people. Exit offer to dissenting shareholders. Devangi will tell where this exit offer came. Only once we have seen exit offer. Where?
Sir,
Two Devangis in class. And that also wrong answer. Buyback, where the exit offer will come? Buyback itself is buying back. Wait, Devangi will tell. Wait, da. Yes, Devangi tell da. You will remember. Dissenting shareholders. Exit opportunity dissenting shareholders. Alteration of object clause in the case of money raised by issuing prospectus. Delisting. என்னடா சொல்ற? That was here capital market noda. Here you don't remember. Capital market you remember. That time you will not remember that. Exit offer to dissenting shareholders. Now what is that I am telling you? Now 10% objected. What will the tribunal say? Either allow them to do or get out of the company. That is what they will tell you. That is only called exit offer to dissenting shareholders. Now once this order is passed by ROC, this order should be filed by the company with the ROC. So tribunal is giving it to the company. Company should forward it to ROC. Which form will they file it? Generally? No, the ROC. Whenever a order is passed by any authorities, that order we will file it to ROC, no?
INC 20.
Very good. INC 28. Where did we see? MOA. Okay, understood. Section 2. What that today? All questions you guys are answering? Simply, Okay. Now understood section 230. Quickly see what happened in 230. A company, members, creditors, liquidator, they will file an application for what? For compromise, arrangements, takeovers, mergers will come in 232. I'll tell you what. We are filing an application with tribunal. Now what will tribunal do? Tribunal may order for the company to conduct a meeting. And I will clearly tell you, send notices to my creditors, my debenture holders, my members, as well as all the other authorities. I will tell a clear notice. The notice has to be clearly sent to them. Now, sir, we will conduct a meeting. Now, these authorities are not allowed for a meeting. So, if they have any objection, they have to object within 30 days of receiving the notice. Now, people, they will send if there is any objection. Tribunal will take it forward accordingly. If they are able to convince, then this particular thing will come to an end. Okay, let us imagine no objection. Then we are presuming that they don't have any problem. Now, meeting will be conducted. Now, people, the meeting, if at all I need to approve, then people, I need to get a majority in number, 3/4 in value of members as well as creditors as the case may be. Such approved scheme will be forwarded to the tribunal. However, if there is any objection, it should be objected by. In the case of members, minimum 10%. In the case of creditors, 5%. And remember, the conducting of a meeting is optional at the discretion of the NCLT. Whenever 90% of the total creditors, if at all they have given no objection, we don't have a problem, we are okay with this particular scheme, then tribunal may dispense of the requirement of conducting a physical meeting. Now, when this approval is given to the tribunal, tribunal can pass any of these orders accordingly. What is the orders? It can say if at all preference are getting converted to equity, then the dividend part is at the discretion of the preference shareholders. Next one is if at all there is any creditors for whom we have not paid or we have not looked at, protection has to be given to them. And if scheme involves any variation of shareholder rights, you have to follow section 48 and the scheme is approved by creditors and whatever the proceedings before BIFR shall stop. What is that? If people have agreed here, there is one more scheme, Board for Industrial and Financial Reconstruction. There is something you are already fighting. Today, BIFR almost does not exist. Equivalent thing is IBC, Insolvency and Bankruptcy Code. So, in some other court, there is already a case going on this credit. And as per Companies Act, you guys were able to compromise. They are telling you whatever the court cases that is going on in other court, all that will come to an end, is what they are telling you. Next one, sir, exit offer for dissenting shareholders. Within 30 days of positive order, NCLT is order will be forwarded with the company to the ROC. Understood? Hello? Pakkana?
Yes.
Now, sir, this is approved scheme. Covilan says, yes, Covilan, this is approved scheme. Now, Covilan has a question, very good question. Sir, what if company does not carry on the scheme as per the scheme approved? Meaning we agreed for something. They are not doing it like that. They said within 20 days everything will be done. Now, within 20 days they did not complete anything. So, they said for 4 preference shares, they will give 1 equity share. They are not giving. So, they said preference dividend will be paid in cash. They are not giving. In such case, can we do anything? Covilan asked. Central government said, don't build a covalent. We have one more section, that is section 231. What is section 231, people? 231 is nothing but power of tribunal to enforce composition and arrangements or compromise and arrangements. Now, what is that, people? Whatever is the order passed in section 230, that particular order shall be foreseen, supervised by tribunal until it is completed. At any given point of time, the tribunal gets to know the scheme is not being implemented as it is. The tribunal can call the parties and it may modify the scheme also. Hey, macha, okay, I got to know 30 days it is not possible, do it within 60 days. Sir, in that 60 days also it is not happening, sir. Sir, you know what? This company, even God cannot save it. Then people, tribunal has a power to pass a order for winding up. So in case of Kingfisher, I made my best effort in 230. We gave you time, 6 months time. You guys were not able to complete what you guys promised. In 231, people, we will try to modify the scheme. If scheme is not possible to modify or you are not able to see a solution there, people, then NCLT will pass an order to wind up the company. Whatever is the money, you wind up and take it. That's all. That's the last thing I can do. Section 231, power of tribunal to monitor or supervise the compromise and arrangements passed in section 230.
So this modification will NCLT is done. Will be in timing, only in timings or the approved scheme?
No, it can be approved scheme. Whatever is not being able to implement it, anything can happen. Now see here, NCLT has the power to supervise the implementation. Okay. And it can also make modification to such composition and arrangements. Okay. If NCLT is satisfied that if compromise arrangements cannot be implemented and company is unable to pay its debts, then people, it may order for winding up. Kingfisher will be wound up. Understood? Huh? Hello? Hello? Huh?
The application filed by the company with the NCLT scenario will only come in time when the company is not in a good situation.
No. I told you Tata Motor also, where DVR was converted to normal share. Then company was doing good only, no. Nothing to do with company's financial situation and all. Now, for example, if you see, you can see this. Read it. Scheme of and section, the scheme of arrangement. Correct? Rationale and purpose of the scheme. The company issued A ordinary shares in 2008 as part of rights issue with the objective of inter alia funding certain overseas investments. The A ordinary shares were issued at a discount to the ordinary shares. The rights attached to similar to rights attached to the ordinary shares in order to voting and dividend as in clause. This was first issue, and as on the date of issuance of there were limited instances of issuance of equity shares with differential rights as to voting and dividend by Indian listed companies with companies market capitalization and size DVR.
If the company is in a good situation, then it will be a discrimination to the creditors.
Like
The company's financials are in good, but still they are applying for the compromise and everything.
if you think the company is financially good, why will creditors agree for the compromise? Why, do you really think you will get 75% approval? You think as a creditor, someone has to pay you 1 lakh rupees. Will you be okay if someone says that I'll pay 40,000 but you have to give an approval? Of course they will not give an approval. So a healthy company cannot go for a compromise. But that's what I'm saying. Arrangements can come. That is possible.
Generally, it will not.
Yeah, generally no. This is clear no? Hello? This is clear? See, this is how the scheme was. Now this is a scheme which will be sent to NCLT. You can see. People, you only. The gun is you only. Certified to be true by who? Malay Kumar Gupta. Company secretary. Clear?
But you said Tata Motors, like, without credit developer, they directly went to NCLT.
Did I tell?
Something like that.
Something like that I didn't tell.
NCLT only, like, only way to go through is NCLT. If they were into not. They did that only one way they did it like that.
EVR into EVR.
So they went compromise only through NCLT.
Correct. Correct.
They didn't go through this process.
They went through this only. That's why NCLT got it. That's why I'm showing it, no? 230 only. That is what was here, no? That is what is given here, no? See here. Shareholders approved. Yeah, approved. That's what is given here. See. Here, no? Hello? Okay. Section 230, 231, any doubts? Hello? Now people see here. Section 232. Merger and amalgamation of companies. Merger and amalgamation of companies. Now sir, what does it say? Section 232. People see here, where an application made under section 230, you are filing an application to the tribunal, it involves a merger or amalgamation of companies, which involves transfer of undertaking, property, liabilities of transferor company to transferee company. What is it, sir? Sir, we are filing an application to the tribunal. For what? There we saw compromise, arrangement, takeover. We are adding one more is merger and amalgamation. So whenever the application filed in section 230, if it includes an application for merger or amalgamation, meaning people, Vodafone Idea came here, they filed an application, everything went through, Vodafone Idea became Vodafone Idea. Understood? So sir, they are telling you in such case, people, you have to follow section 230 along with 232. Why? Because transfer of undertakings, assets, liabilities will happen. Why is that, sir? Earlier the shares, the assets, the property will be in the name of Vodafone. It will be in the name of Idea separately. Now everything will be transferred to the name of Vodafone Idea now. Transfer of assets are happening, right? Yes or no? Now sir, for this they are telling you, you need to go to the tribunal. Section 230 and 232 will apply. Understood? Now what will tribunal say? If tribunal is satisfied, people, tribunal will tell you to go ahead with your merger and amalgamation. It will pass an order. That is what we saw as per Indian Stamp Act. Whether on the court's order is stamp duty applicable. This will become the court's order. Understood? Hello? Yes or not? Okay, now see here. Where an application made under section 230 involves merger or amalgamation of companies which involve transfer of undertaking, property, liabilities of transferor company to transferee company. Transfer is old, transferee is new. Okay, in such case, the tribunal shall direct so and section 230 to 236 shall apply mutatis mutandis. ये क्या है 233 to 236 notice sent to conduct a meeting. Whom and all the notice is sent to? Whom and all the notice sent to? Creditors, members, debenture holders, authorities, and voting. How many people should vote? Majority number 3/4 in value. Objection 10 5A shall mutatis mutandis apply here as well. You need to conduct a meeting for a scheme to be approved. Again, majority number 3/4 in value. Objection 10% or 5%. Same thing will apply as it is. Is clear? Pakka? Okay. Now, sir, in addition to the notice specified in 233, that is, we are sending notice to the creditors, debenture holders, and all. They're telling you the following documents shall also be sent in addition to what is given in section 230. What is that? Draft of the proposed terms adopted by the merging company. Meaning, Vodafone Idea, you're coming together. No, what are the terms of that merger? You have to give that. Meaning, I need to know my equity shares will be taken away from Vodafone. How many new shares will I get? Or if I'll get some money directly, how much money will I get? That I need to know. That is what is proposed terms. Next one, confirmation of draft scheme filed with ROC. Before you do any of the scheme, you have to first tell that the scheme is first approved by ROC. Get ROC's approval first. Okay. Effect of compromise on shareholders, KMP, promoter and non-promoter. Whatever this particular merger is going to happen, what will be the effect on your directors, promoters, KMP? Are they getting benefited? Or what will happen to them? Give the benefit or give the impact of this particular merger and amalgamation. Next one, valuation report. What is valuation report? One share of your old company, what is the value? One share of the new company, what is the value? You will get it by a valuation report. Next one, supplementary accounting statement, nothing but your accounts of the company, current financial statements of the company. All this will be sent to my debenture holders, creditors, members, along with the notice given in section 230. Clear? Okay, now what will the tribunal pass? Tribunal will pass an order provided if the scheme is approved in your meeting. That is, we are assuming that 234, 5, 6 is done. Scheme is approved. Approved scheme is now sent to NCLT. Now what will NCLT pass an order? NCLT shall pass an order sanctioning the scheme, approving the scheme, plus it will make a provision for following matters in its order. It will include all this in its order. What and all? The first one, transfer of undertaking, property or liabilities to transferee company. From Vodafone, all the assets will get transferred to Vodafone Idea. From Vodafone, all the liabilities will get transferred to Vodafone Idea. Going forward from this date of the order. That will be mentioned in the scheme that is passed by NCLT. People, now on this, should I pay stamp duty? Is that entire thing we saw. Got it? Hello? Next one. Allotment of shares, debentures or other instruments by transferee company. Popularly in your accounting terms, this is called as purchase consideration. What are we giving? Are we giving shares? Are we giving money? Are we giving debentures? Mention that. Huh? Not able to see here. Purchase consideration now. Correct? Sir, transferee company shall not hold shares in its own name. What do you mean by this, da? Transferee company shall not hold.
Vodafone should not have shares in Vodafone.
How will that happen?
Idea should not have shares in Vodafone.
Whatever you tell, I'll draw. Tell me.
Vodafone Idea
Vodafone Idea.
should not have shares in Vodafone.
They should not have shares in Vodafone.
So it's not.
The transferee company shall not hold shares in its own name.
Getting merged, its name.
Okay, Vodafone Idea is getting merged. Okay.
It should be held in the name of Vodafone Idea.
It should be held in the name of Vodafone Idea. What should be held?
Shares.
Shouldn't be.
Share should be held in Vodafone Idea's name only. Who should hold? Someone says, what Abhijit?
Idea shouldn't hold shares in the Ideas company. No.
Vodafone Idea cannot hold shares in Vodafone Idea.
Everything changed to
Okay, generally what will happen, people, see here. Now people, let us imagine, you can imagine this way. Vodafone has some 2% of shares in Idea before merger. Now let us imagine Vodafone takes over Idea, meaning we are acquiring Idea. Now Vodafone Idea is becoming one. Now I need to pay purchase consideration to all the shareholders. So what are we deciding to give? We are deciding to give the equity shares for all the shareholders, whoever were the shareholders of Idea. If you were shareholder before, you will become shareholder after also, but proportion will change. If you had 10 shares in Idea, probably you will get 2 shares in new Vodafone Idea. Now who and all were shareholders in Idea? Vodafone was also shareholder in Idea. Now they both are coming. So Vodafone Idea are now becoming, Vodafone and Idea are now becoming Vodafone and Idea. Yes. So they will start giving shares to all the Idea shareholders. They will start giving to all Vodafone shareholders. We will start giving shares to all these people. Agreed? Hello? Yes or no? Da? Now my question is, what if Vodafone only had some shares in Idea? We will have to give them also shares? Yes or no? Now Vodafone is becoming a merged entity. Can my company hold my own shares? Can company hold its own shares? Not possible is what they are telling you. In such case, what you need to do, you have to settle it in cash. Your own shares cannot be given to you only. It can never happen. I told you one logic also. Imagine if you call for a general meeting. We will only vote. Is it possible? That is what they are telling you. Now see, transferee company shall not hold shares in its own name. Meaning, whenever the shares are being given to you, if at all you were a previous shareholder, you cannot get a new share in the new company. You will be settled with money. Shares won't be given to you in such scenarios. Is what they are trying to tell.
Idea shouldn't have had shares in.
If Vodafone had shares in Idea,
Transferee.
a transferee company is Vodafone Idea now. New company is Vodafone Idea. Now Vodafone Idea will start giving shares to all the previous shareholders of Vodafone and Idea. So in Idea, Vodafone is also a shareholder now. Now can I give shares to him? Not possible. Because it will be like me giving shares to me only. That is not possible. As cash, it will be settled. Understood? Hello? Pakka na? Okay, next one's here. What else? Continuation of legal proceedings in transferee companies name. Simple. Some cases that were going on in the Vodafone name will continue in Vodafone Idea's name. Of course, cases will not come to an end. Agreed? Dissolution without winding up of transferor company. What is this? The dissolution of transferor company without winding up. What do you mean by that?
Without getting winding up to get sorry.
Okay, Vodafone Idea.
Vodafone
Okay, Vodafone Idea. Vedna.
Transferor company will get dissolved without applying for winding.
What do you mean by that?
They'll cease to exist, sir.
So Vodafone will cease to exist. That is only called as without winding up. Is what you are saying. Understood, all of you? Hello. Dissolution without winding up means what? Very good. See here. Vodafone Idea. Vodafone Idea is becoming Vodafone Idea na. All the assets in Vodafone is being transferred. All the liabilities are being transferred. All the legal cases are being transferred. Now my question, what is left in Vodafone? Tell me. What will be left? Nothing. Now why should I conduct a winding up procedure? What is winding up procedure? Should I appoint a liquidator? Should I sell all the assets? Should I give it to all the creditors? Is it required? Not required. Okay, if that is not required, but should Vodafone continue or should the Vodafone come to an end? It will come to an end. Everything is transferred. That is what they are telling you. Vodafone will be dissolved, but not by following the order of or procedure of winding up. There is nothing required. Winding up is not required, but still the company will cease to exist. It will be dissolved. The company will not continue. But you will need not have to follow liquidation procedure. Meaning I need not have to sell my assets. I need not have to repay my creditors. Everything will be transferred to Vodafone Idea. That is the new company's name. Hello?
Sir, is Vodafone Idea merger or amalgamation?
You take it as merger only. For our thing, merger same only. Just take it like that only. Clear, huh? Hello?
What is the difference between merger and
Almost same only. Da. Generally depends upon if it's a new entity that is formed, we call it as an amalgamation. Merger is one entity is merged with another entity. Like Vodafone and Idea come together, and Vodafone will come to an end, and they will continue as Idea. That's called as merger. Vodafone and Idea becomes Vodafone Idea. Now we call such things as an amalgamations.
if a new entity formed?
New entity comes into picture. In merger, no new entity will be there. One will cease to exist, other will continue. But I am telling you, as per legal laws, there is no difference. The difference exists in IT laws. Income Tax Act, there is a difference.
In amalgamation, both will dissolve.
But I am telling you, actual difference happens in IT law. For something to be called as an amalgamation, there are some conditions to be satisfied. Like my previous shareholders should be there in current company also. Like that, there are many conditions. I mean, I will not tell you all that because it is very confusing, but yes, that is there. Maruti and Suzuki. Maruti is there. Suzuki is there. When they both exist and they are also coming together with another one, that's a joint venture. They are continuing to exist. Hero Honda, all that. Starbucks, Tata Starbucks, everything. Clear? Hello? Now, okay.
So then what will the difference between takeover and
Vodafone also will continue. Idea will also continue. Who was Vodafone's owner? X. Who was Vodafone Idea's owner? Y. Now Vodafone came and acquired Idea. Who is the owner of Idea? No longer Y. If it is Vodafone, that is the owner of Idea. But Idea also exists. Vodafone also exists. Ownership changes. It's called takeover. Illa. Facebook exists. Is Facebook still there? Of course, Meta. Is Meta still there? Is Meta still there? The Meta is there. You guys use it. WhatsApp there. Who was the owner of WhatsApp? Some foreigner. Correct? Is WhatsApp still there? Meta acquired WhatsApp. It's not merger or amalgamation. WhatsApp is also still there. Meta is also still there. But the ownership changes. WhatsApp is now under the ownership of Meta. That is only called as acquisition.
What the other one? Twitter?
Which one?
Twitter?
Twitter? Acquisition only.
Acquisition is
I was about to tell that. Remember, acquisition and holding and subsidiary company are not different. It's same.
is in 100%.
Ownership is changing, that's all.
Not always 100%.
Majority, 51%.
Twitter is also majority.
Majority, yeah.
Fully owned.
Yeah. Understood? Hello? Pakka na? Okay. Correct. Hotstar and Jio is a merger. Correct. Hotstar is there. In our thing, they have now merged with Jio Hotstar, no? Correct, no? Now Hotstar also separate platform is there. I want to watch Hotstar as a separate platform. It's there without Jio in that. No, one entity will come to an end. So in a merger, always one entity will come to an end. Understood?
Only one subsidiary, 100% is it? company there should be 2 members.
Now this will be answered by, I'll tell you it. Srishant will answer it. Illa, then you don't answer it. Matthew will answer it. Matthew, tell da. Yes, someone tell da.
Only one subsidiary.
All of you listen. This question can come to you guys also. Meaning, me asking you.
Only one subsidiary. Its 100% share will be with the holding company. So in a private company there should be 2 shareholders. What is that process?
Wait. Now, Matthew, tell da.
Other possible employees, maybe it should be
Manoj, tell da. Correct, Section na. Section 187. After gills you saw. Investments made by the company directly will be held by the company in its own name. Whenever there is a wholly owned subsidiary, but to satisfy the limit, what a wholly holding company, what will it do? It will say, hey, come down here, 1 share you hold. As a registered holder, you will hold. Beneficial owner of that 1 share also will be me only. Why are we having 2 shareholders? To satisfy the limit of 2. The minimum shareholders requirement. 187. Clear? Hello? But yes, very good. Whoever is able to recall, very good. Very good. Okay, people see here. Transfer of employees of transferor company to transferee company. Simple. Because of this order, all the Vodafone employees will become Vodafone Ideas. Ideas will become Vodafone Ideas. Hello. Next one, if transferor is a listed company and transferee is unlisted company, what will happen? Here, macha. Hey, macha. Vodafone is a listed company. Idea is also a listed company. Now, what will happen to Vodafone Idea? Of course, it is unlisted. Hey, you have to make an application again. Terms would have changed. By default, if a old company is listed company, whichever is a new company it is going to become, by default it will not become listed company. It will get listed only when you list it. A separate listing application is required, mandatory. Macha, if that is not the case, it will become a shortcut to become listed company. Sahara could not become. What is the easiest way? Get acquired by some listed company. Easiest way. That cannot happen, Kanna. It shall continue to be unlisted. Exit option to dissenting shareholders. Similar. The fees paid by authorized capital of transferor company shall be set off against the transferee company. Agreed? What is this? Vodafone Idea. Vodafone's capital was, authorized capital was 10 lakh. Idea's capital was 5 lakh. They would have already paid fees respectively. Oh, why they have done this? 1 second. You want to see? The people, now imagine Vodafone was 10 lakh, the Idea was 5 lakh. What will be their new authorized capital? The new authorized capital will be 15 lakh. Why? Because for this they have already paid fees to the registrar. Nothing new is happening. The capital will get added up. So telling you, whatever the authorized capital fees is paid on the previous companies, that will get added to the new companies. You need not pay the fees again, is what they are telling. Fees, regulatory authorities, whatever are the forms you file, the fees will always be on the authorized capital. So if you have filed anything already, you need not file it again. That fees is considered as paid in the new company only. Again, you need not file it. Clear up? Hello? Hello? Such certified copy of the order of the tribunal shall be filed with the registrar for registration within 30 days. The scheme shall indicate an appointed date from when the scheme shall be effective. So whatever is a date mentioned in that particular scheme, that this is the appointed date, from that day that particular scheme will be considered as implemented. Meaning in the scheme we have written that the implemented effective date or the appointed date is 1st January 2026. The scheme was approved by NCLT on 31st March 26. The effective date of the scheme will be still 1st January 2026 only, not the day the tribunal has passed an order. Whatever you have given as an appointed date, meaning effective date in your scheme, that will be the effective date from which that scheme will be considered as effective. Clear up? That is only called as appointed date, which will be mentioned in your scheme documents. The last one, until the completion of the scheme, every company shall file the statement with ROC every year, which is certified by the practicing chartered accountant or CS or a CMA, indicating whether the scheme is being complied as per the tribunal's order or not. Meaning, sir, this merger is taking 3 years. Every year end, people, a form has to be filed with the company. Which company? Vodafone also has to file, Idea also has to file to the to ROC. It is filed every year. Until when, sir? As long as this particular scheme is not completed. Imagine if it is taking 3 years. The entire 3 years, year end, what is the status? What is the status? What is the status? And that particular status has to be signed by a practicing chartered accountant, cost accountant, or your company secretary, as the case may be. Clear?
Companies getting merged or amalgamated, name will be changed, no? So arbitration of names also.
Hmm.
Then which companies need to be given for at least 2 years? Old name should be mentioned, no? For 2 years.
You will mention that only.
Both companies.
Previously referred to as Vodafone Idea. You will be writing that. And it's not always considered as old company also, no? People will write it. It is Vodafone Idea amalgamated. But it is not considered as even a, what do you say?
Company changing.
It is not considered as a legal status of the same company. It's a new company coming into picture. So because of that is happening. So it can be even waived off also by the tribunal if need be. So if you see Jio Hotstar, they don't write I was Jio before, Hotstar before. It can be waived off as well. Clear? 232, any doubt? Hello. 232, any doubt? Okay. 232, what is 232? Summary items. Because whenever an application filed under section 230 includes or involves a merger and amalgamation, people, you need to follow section 232 as well. But remember, section 233 to 236 mutatis mutandis will apply. But along with the notice sent as per section 233, even following documents also have to be sent. What are the following documents, people? Draft of the document, purchase consideration to be paid, valuation reports, the scheme, proposed scheme. Now all this will be sent to in addition to your 233. Now sir, if everything goes good, same thing, 233 to 236, objection no, approval no, mutatis mutandis will apply. The NCLT can pass an order mentioning following things in its order. What is that, people? First one. What will it mention now? Transfer of assets, shares, properties, liabilities in the new company's name. Transfer of cases, pending litigations in the new company's name. Transfer of employees from old company to new company. Dissolution without winding up. Exit opportunity for the dissenting shareholders. Purchase consideration to be paid as per equity, debentures, cash, as the case may be. If at all your transferor was listed, automatically transferee won't be listed unless an exclusive application is made, and whatever is authorized capital fees paid will be set off even in the new company's name. Agreed? Hello? And whatever is the order passed by the NCLT will be filed with the ROC within 30 days. And remember, until this merger amalgamation is not completely completed, every year you have to file a status update, people, in form, certified by practicing professionals, that is your CS, CSMA. It has to be filed every year until the complete scheme is completed by both the companies or whatever the company is involved. If it is 3-4, then everyone has to file. Correct? No? Can that happen? 3-4 companies can club into one company. Can it happen? Can it happen? State Bank of Mysore, State Bank of Travancore, Hyderabad, everything merged into State Bank of India. Possible 230 only. 232 only. Transfer of employees. We have seen this also. Tell me where. Who will be the director? Okay. Sudarshini's question. In Vodafone there were directors. In Idea there were directors. What will happen to them? They will become directors of this company. Where did we see? Compensation for loss of office. If at all corporate restructuring, of course they will look into all of this. When you are offered a new position in the corporate restructured, basically a merged company, then I need not have to pay compensation for loss of office. Hello. Hey, but nice that today you guys are all first time speaking technically. Very happy, but very sad. Last day you guys are speaking. I don't know what happened, but okay. Okay, fast track mode of merger and amalgamation certain companies. The people. Mithun says, sir, who sir will follow all this 1 year, 2 year and all? I don't have patience. I want to finish it off takatak. Do I have any scheme like that? Takatak I have to finish it off. Which is like, see, wonderful, no? How we have correct now? Now people, trust me, if we have to write this and we have to see this, it will take at least 2 classes. First of all, at 2:30, you see, sir, you went there, sir. Sir, where did that go, sir? That arrow mark, why is there? Okay, now see here. So people, 233 is nothing but people. Same, merger and amalgamation only. But people, for impatient people. Impatient. So people, that is only called as people, fast track merger. Now Nitin asks, sir, anyone can do fast track merger. Jio and Hotstar can do fast track merger. Possible. Then, it's only for few companies. Who are those companies? Those companies are called as people, certain companies. Who are those certain companies? They are, one is people, 2 startup companies. Possible. 1 or more startup and small companies. Possible. So people, there can be a merger between 2 startups, between 2 small companies, between a startup and small company. Possible. All permutations possible. Now they need not have to follow 232. They can come under 233. Sir, mandatory. So 2 small companies should mandatorily come under 233. They say no. When you are sitting in India, of course, you have right to speak, fundamental rights. You are choice, macha. If you want to go under 232, if you want to come under 233, your choice. Mithun macha. Understood? Okay. Now see here. Now sir, with whom all it will happen, people? See, any other company as may be prescribed between 2 startups, 1 or more startup and small company. This was recently added. Startup to small company was recently added. Sir, previous to them who were there? Previous to them, holding company and wholly owned subsidiary were there. And 2 or more small companies were there. No other permutation was there. So recently they have added startup and small companies also allowed. Startup and startup is also allowed. That was a recently introduced amendment. So it can happen now between holding, wholly owned subsidiary. 2 small companies. Startups 2. 2 small companies. 1 startup, 1 small company. Everything is allowed. 2. Wait, no. Wait, not 2 da. 2 or more, of course. Hey, Yogita.
It says 2 or more.
2 or more. Yeah. Provided they should be them.
startups.
That's startup and small company.
So one or more startup
Oh,
and a small company. Possible. You can never say it is only two node. Understood? Possible. More than two possible. 100% possible. Understood? Hello? Hello? Okay, now how is that, sir? Why is there a fast track merger? See here, every company that is transferee. Let us imagine there are two startups only coming together. Both the startups, transferor and transferee, shall formulate a scheme. Such scheme shall be sent to, meaning we are telling that a company X coming company Y, they both are coming together. So it is going to become XY. For our shareholders, we are going to give so much of equity, so much of debt, so much in cash component. All the employees will get the positions here. Who will be the directors? What is the revised board? Where will be the registered office be? Whether in your place or my place. Now Jio Hotstar, logically think, it is the what? International transaction. Where will be the registered office be? Which laws will apply to us going forward? Where will be operating from? Everything will be approved, people. That is what will be approved in the scheme. Now such approved scheme, whatever you guys are coming up with, such a scheme shall be sent to whom and all. One, we will send it to ROC. Next one, we will send it to liquidator of both the companies. Why? Creditors are involved. Wherever creditors are involved, people, liquidator will come into picture. So we are sending it to the liquidators. Next one, people, person who shall be affected by the scheme. Whoever will be, we think, because of this, they will be affected. We will send it to them also. It can be authorities, it can be people, it can be employees, whoever. If we think because of the scheme of merger, if they will be affected, we will send this particular scheme to them. If PVR is?
Monopoly, right? So PVR is a monopoly.
They
will send it to the competitor who are getting affected.
PVR is it's a monopoly. So it send notice to its competitors like other because they are also getting it.
What I'll tell. I just appreciated, Noda. Okay. You need to why will PVR send it to Inox, Cinepolis and all that? They are affected. They ennada question. They you will send it to people affecting in your company, da. Why will you send it to your competitors and all? Okay, now see here. Such suggestions or objections, no people. Now why are we sending it to them? We are sending it to them people because for inviting suggestions or objections. ROC, if you have any problem, let me know now only. A liquidator, if you have any problem, let me know now only. We will take their suggestions, people, and such suggestions or objections are considered by the company. Now we have formed the scheme. No, ROC has replied, these are my concerns. We will make changes to all those schemes. Whatever the concerns have been said, we will make changes to all those particular concerns that has been pointed by these authorities. Getting the point? Okay. Now, sir, considered by company in general meeting. Now that whatever is a revised document, now we will call for a general meeting. Now shareholders, you come. And now you creators, you come. Now you come. So, sir, such a revised scheme shall be approved by if members people then holding 90% of the total number of shares, meaning I'm telling in value. If it is people, majority, creators are there people, majority representing 9/10 in value of creators, majority representing 9/10 in value of creditors. So sir, if we have both, we need to take approval from both. If we have one, we will take approval from one. So sir, what is the difference between 232 and 233? Why is it called fast track? Because we do not go to NCLT here. The entire process is skipped. There is no reporting of NCLT done at all here. So you think in a court, when will you get your date of hearing? It's a time consuming process. Now they will ask you something today. You can't go and give it tomorrow. You need to go to your adjourned date. That can take 30 days. That can take even 60 days. You need to have patience till then. Now in this particular method, that time will be saved. I getting a difference all of you? Okay, 90%. Next one, sir. Such approved scheme shall be filed by the transferee company with, again, we are sending it to ROC and liquidator. We sent no first time here. We sent no first time here. Why are we sending it again? Because first time we had sent them a draft. Now they have also shared some concerns, some changes. Now we are telling we have made changes in our document. Now shareholders creditors meeting also happened. They might have also suggested some changes. Now all that has been incorporated, whichever ROC and liquidator is not aware yet. Now we need to show it to them also. What has been the changes? What is the final copy? We will give it to our ROC and liquidator. Now what will they do? And simultaneously such approved scheme, we will give it to the central government as well. We will give it to ROC and liquidator. Simultaneously, we will send it to the central government as well. Now, what will central government do? Central government will wait for the ROC and liquidator to file their objections, if any. Sir, we had shared these changes, sir, but the company has not changed it at all. It's a major one. They have not changed it at all. So, it's a concerning one. So, ROC and liquidator can give their opinion to central government, not to company. They will give it to central government. Now, what will central government do? Central government, imagine two scenarios. First scenario, ROC and liquidator has no objection. They are absolutely fine. Sir, they have done everything as we said, so we don't have any issues. In such case, people, the central government shall register and issue a confirmation to the company on such a transfer, that is merger and amalgamation, and that particular document shall be filed with ROC. So let us imagine ROC and liquidator, they showed some issues to the central government. They said we have concerns. In such case, sir, if there are objections, CG is also with an opinion. So they have raised concerns and central government is convinced with the concerns raised by the ROC and liquidator. Yes, you are telling this, it is valid point. Even I am convinced. And I think that the scheme is not in the interest of creditors or public. Whatever this is, this merger, I wouldn't think that this is good in the interest of the creditors or for public. In such case, people, central government will say, don't do one thing, don't come under shortcut, you go under long cut only. So the 233 application will be pushed to 232. Meaning what, people? You will go under tribunal's route. Forward the application to the tribunal to consider the application as per section 232. So, whenever you file your application to ROC and liquidator, if they have any concerns, they will say, yes, we have concerns. Now they will give their consent to central government. What will central government do? Even it will also try to consider what are the concerns. If the concerns are valid and I am also justified with whatever concerns you have, I will tell, do one thing, you do not come to me directly, you go to NCLT, your application will not fit in 233, you have to go to 232. There is no fast track, you have to go to regular merger and amalgamation. Clear, huh? Sir, what if there were no objections at all? Central government will say, then absolutely fine. I don't have an issue. CG will just confirm an order of merger and amalgamation. You guys are? That order will be passed to the company. The company will have to forward it to ROC. Clear, huh? Hello? See, you only tell me, if given a choice, a normal company, will it go under 233 or 232? Of course, the certain companies, eligible companies. Whether will they go under 232 or 233? 233 or 232? You will go under 233 when you know that you have 90% majority at your end. You think you are not going to get 90%, you will go under 232. In 232, I just need 75%. So it favors you there with regards to the number of approvals. Now you say, no, sir, what if I don't have 75%? Now my question, what if you do not have 90%? You might have 80. You might have 78. In such cases, people, 232 will help you, not 233. In 232, what is the voting required? Majority number 3/4 in value, no? Yes or no? That's all. You will get it. Here how much? 90%, no? That's how you need to read it. That is where advisory brain will come. Hey, goes at 233. You come here, shortcut. It doesn't work like that. You need to ask your person how many of them are in favor of this particular thing. If the number of people against are more, 233 won't work. Then you need to go under 232. That's the only choice. Are you getting it? Yes. So in 233, how do we do? The company itself will come with a scheme. That scheme will be first sent to ROC, liquidator, any other person going to get affected, concerned person. We will ask for their objections and suggestions. We will consider that objections and suggestions. After considering that, we will call for a general meeting. In general meeting, people, I will take up the matter. I will call my shareholders. If I have creators as well as creators, I need to get a 9/10 here and there. So if I get an approval, people, such approved scheme will be filed by the company with ROC and liquidator. Simultaneously, I will also file with central government for the approval. Now, sir, if at all ROC and liquidator, if they have no concerns, the same will be communicated to the central government. We have no objection, sir. Central government is also satisfied, people. Central government will pass an order for merger under 233. That order will be filed with ROC within 30 days. If at all ROC and liquidator, if they have an objection, people, the same thing will be communicated to central government within 30 days. In such cases, people, central government will take it based on merit basis, meaning hearing will happen. If it's in the public interest, if it's in the creator's interest, then they will say, no, ROC, your interpretation is wrong. If they think, no, this particular thing, what ROC said is right. This scheme is not in the interest of public, not in the interest of creators. Even I am convinced. Then I will cancel. I will say, you go as per section 232, you will go under tribunal's route.
If CG has that opinion that this is not the interest of creditors and the public interest, so they will forward it to tribunal.
Correct.
So they have to start from scratch.
Correct. Everything.
Once he finishes it.
No. Because first thing, tribunal will take it up. First thing tribunal will tell us, you forward the notice to all the shareholders. Everything will start now because approvals, percentages are different. Correct?
It's 90 here.
Here 90, there 75, 3/4.
So it's 90 here already. Still wants to.
Because the number of applications you have sent, to whom and all you have sent, have you sent to all the other authorities? That everything is not satisfied yet. So all that will come into picture. We have not given to IT, we have not given to SEBI. Clear? Hello? Pakana? Section 233, any doubt? Hello? 233, any doubt? Okay, see the last part. The registered scheme shall transfer property and liabilities. Charges shall continue. Exit opportunity as it is. Legal proceeding shall continue in the new name. Fee of authorized capital shall be adjusted. Same thing whatever we saw in 232. And remember, company has its discretion to choose between 230 or 230 to 232. This is 233. Correct? 233. It's clear all of you? Yes. That is 233. 235, 26. You want bacon, huh? Kanna vaida, huh?
Not 234.
24 is there, that we'll see here. Okay, we'll do up 234 because Kanishka reminded we'll finish it off. Simple one only, theta. People, what if Jio and Hotstar are merging? Which section will apply? Jio and Hotstar. Jio is from India, na? Hotstar is from outside, whatever sections are applicable, that sections will apply. Just in addition to that, one more approval will come. That's all is 234. RBI approval, FEMA laws will apply. Page number 10.16. Foreign companies. See, merger or amalgamation of company with foreign company. Hey, foreign company is not the definition which we saw. What is foreign company? A company registered outside India, having a place of business in India, not that one. Foreign company is actual foreign company. Meaning, generally we see no, a company which is from outside is called foreign company. That is the meaning of foreign company here. A company registered outside India, whether it is there in India or not, it's a foreign company. So when we are merging with such foreign companies, they are telling you the provision of this chapter shall mutatis mutandis apply. Agreed, with the prior approval of RBI. Hello? That's all, nothing else.
Section 233 won't apply.
No. Because startup is only a company registered in India, no? Clear, So what I was saying, 232 will as it is apply, no change. 230 if it is there as it is will apply. 233 will not come into picture, of course. Then what can come into picture? It will be only these two, 232. In such case, they are telling you, you follow same thing. This chapter will as it is apply. Section 232 will apply. In addition to that, also take RBI approval. That's all. Meaning NCLT approval you are taking. In addition to NCLT approval, you will also be taking RBI approval. Hello? Understood? That is 234, nothing else. Hello? Hello? Okay. I go for a break and come. There people are. Okay, we'll see this after the break. But understanding this chart, no? Macha 5 pages, sir. If you go here, it is 16 pages, sir. 234. Now 235 10.16, 10.17 is your 235. It's a lengthy procedure. When you guys are going and studying also, go today. Go through the PDF only. You keep the chart next to you and you compare and study. Because we would have consolidated everything and it is a flow. So we would have said, no, go from here to there. After that, come here. Like that, theory and text will not be given like that. It will go in some flow. For you, you can connect, okay, in the chart it comes here, oh, that means like this, after this step, this is coming. You never know. Yes. They will ask. Clear, Okay, go for a break and come.